like to give each of you an open mic opportunity to, big picture, give me your thoughts on 101. Well, maybe I'll just stop there. Give your opening thoughts on 101 that you want people to understand as we start to try and peel back the layers of the onion. Andrei, why don't we go to you first?
Well, first of all, I lost my voice this morning, so I will speak very closely to the mic. Hopefully that works. Great to be with you, Gene, and with everybody here again today. So 101 in the courts, as I'm sure you'll hear from the co-panelists, remains quite a confusing mess. Nevertheless, there's a lot more, quite a few more cases that have been decided, and you can always find analogous cases on one side or the other to guide your approach in litigation. So the body of 101 decisions over the past decade has grown dramatically from the federal circuit and the district courts, and I think that's helpful. It's provided additional guidance. But I think what we're going to do is, Vince is going to talk mostly from the litigation side, John a lot from the prosecution side. There's a lot of overlap, of course. And I'll try to provide a bit of a view from the government side, both in the administration and in the legislation. I do think that at the PTO, the situation is much improved over the last few years. The reality, we put out the 2019 Patent Eligibility Guidelines. So they've been around for 6 years now, and obviously a lot of patents, tens of thousands of patents, or probably millions, over 1 million patents have been decided with these guidelines. And it works fairly well. The courts have not adopted the guidelines, though. Neither have they said that they're wrong. And I don't think they are. I think they're fully consistent with federal circuit law. So there's a lot of experience with the guidelines. And I think overall, on balance, there is a certain level of predictability when it comes to 101 during prosecution at the PTO or in administrative proceedings, whether it is re-exam or PGR that takes into account Section 101, mostly PGR, actually. To address all of this, there is a pending statute, Patent Eligibility Restoration Act, which we can talk about during the panel. It was introduced in the last Congress fairly late. And as you know, at the end of a Congress, all the bills that haven't been acted on disappear. So that's what happened in the last Congress with PIRA. But it was reintroduced again just recently, bicameral, bipartisan, so the bill is now pending. I think it would go a long way to address the confusion that remains in the courts. So that's at a high level, and we can get into details, Gene, when we're ready.
So the one quick thing, I can't help but crack a smile when you say the body of 101 case law gets bigger and bigger. I think that's a great characterization for it, as the body, like the dead body, kind of. So that's my only commentary at the moment. But thank you, Andrei.
The body of law is a dead body of law, right? Is
that particular body of law is very dead.
Okay.
So thanks, Andrei. Appreciate it. Vince, to you from the litigator's perspective.
So just as a little bit of background, what we do is primarily plaintiff side patent litigation, and we work a lot with litigation funders who fund a lot of our cases. So what my clients want and what our funders want, and our clients' funders want, is certainty, of course. They want to know, is this patent good? Is it going to survive a 101 challenge? And based on the body of case law, you could say, really, nobody knows the answer to that. So what can we do to really get someone to an answer? And we're not working with new patents. We can't really change the claims. You're going to hear some of that from the prosecution side. We're working with patents that were prosecuted, maybe a few of them 4 years ago, a lot of them a decade ago, some of them even 15 years ago, before any of this case law was out. So really, what do we tell our clients about the certainty they can get about 101 it's, kind of what Justice Stewart said, you know it when you see it, right? Like obscenity law, basically. You know something is an abstract concept when you see. You can look at the claim and say, come on, this is nothing here. Or, an engineer can look at the claim and say, okay, this is, it's a long claim. It's got a lot of method steps. There's more to it. So that's at the high level. Really, it's the kind of thing that you know it when you see it. You've seen it enough, and you could tell something is going to survive a 101 challenge. I do think this is the area of law that AI is never going to come after us for, because it's not something you can just plug into a model and have a computer spit out. It needs human creativity to get to the bottom of. And I guess the final point to this is, no matter how hard you prepare and how great of a complaint you put together, or preparation you put together, or expert testimony you put together before filing a case, you really have no idea what your defense to 101 is going to be until you see a motion come at you, a motion to dismiss, a motion for judgment on the pleadings, something in an invalidity contention. Because the secret to beating 101 from a litigation side is trying to diffuse step one primarily. And you don't know what your argument is going to be for step one until you see how the defendant has tried to frame the abstract concept, right? So trying to look at it in a vacuum without knowing how the defendant is going to frame it is impossible. You only really know what your arguments are going to be when you see the abstract concept. And that's how we've had some success, has been you get a very narrow abstract concept that doesn't capture the whole claim, and then all of a sudden there are limitations that come in and haven't been captured by the abstract concept, and you've beaten step one. So, again, really, it's a case-by-case basis. It's the kind of thing where once you've seen enough of them, you could say, okay, I think this one might get through, I think it might not. But really it comes down to those battlefield decisions about reacting to a position that's taken in a litigation.
Okay, awesome. Good start. John, from the prosecution perspective.
Sure. So I would say from the prosecution perspective, we do a lot of AI as background, and especially for those cases, you have to have an eye towards an invalidity challenge from the moment you draft the title, not even just starting at the background. I mean, from the very top. There's no other way around it, and you have to sort of get creative and think of every backstop you can, every embodiment and implementation you can to put into the spec. You have claim strategy where you, even if you're going to go broad with the independent claims, which is fine, you need to have some implementation details to get past 101 in the dependent claims, so that when you get into litigation, claim one isn't just treated as representative of all claims. I would also like to add to what Andrei said about the policy. First of all, I appreciate the 2019 guidance. I agree with you that I think it is consistent with the case law. But I would like to add, and Gina and I have talked about this, that I think it illustrates the sort of sickness and the chaos in the system right now. And it's not a way, it's a threat to federalism. There's no reason why an administrative agency should be adding the practical application step on top of what the federal circuit is given, but for all the uncertainty. And again, I'm grateful for you doing it. You saved my clients a lot of money. You saved me a lot of headache. But it demonstrates how the rest of the system is not doing their job when it's on the director of the patent office to provide clarity on what's otherwise a common law test. And I think something really needs to be done. It's a call to arms. Gene, yesterday you talked about how to get members of Congress interested to pass para or other pieces of legislation, we need to be at like a true emergency level. And when you said that, I thought to myself, we're already there. Mm-hmm. I mean, I don't know how much more you need what else needs to happen for members of Congress to pay attention. China has stronger eligibility laws than we do. They're eating our lunch when it comes to AI, and it's only going to get worse. And if we can't even get members of Congress to pay attention in that context, with all of the AI and the R&D going to China, I don't know what's going to make them pay attention, but they need to start.
So I think I can give some thoughts there, and Andrei, I'd like to get your thoughts on this. I think that fundamentally one of the biggest problems throughout my entire career, and probably going back well beyond my career, is that the people who don't like patents just fundamentally think innovation is going to happen because innovation happens. They don't believe that people will stop innovating. And I don't understand why they don't get that. I mean, because what we've seen is since all this eligibility issue has gone to hell in a handbasket, really, investors are investing in safe spaces. We don't have investors investing in medical diagnostics because you can't patent a medical diagnostic. We don't have investors investing at the same level in companies that are making software solutions and AI. They're investing in social media, and they're investing in pop culture things and apps, and it's a race to get more users than it is to innovate something that's really useful. And I get that, right? I mean, because it's a smarter play, it's a safer play. You don't need patents. You just race to be first, and then you get bought out. So I don't know what we can do to get Congress to understand this. And I had thought that the China connection would be the thing, you know, the same way it was with the Japanese connection back in the 80s. You know, we were afraid the Japanese were going to eat our lunch in terms of technology, and it hasn't planned out that way. And I wonder whether it's because we have this multinational global IP system, and whatever we do here in the U.S. that will help U.S. disruptors, I think there's a perception that it will help disruptors from other countries. So, well, then we can't be in favor of that. So we're just going to have to keep the status quo to protect our biggest companies. And I think that that's not the right place to be. But I don't know what the answer is. I don't know what gets us out. So, Andrei, have you given some thought as to how do we get members of Congress, or what might be the pivot moment, or do we need a real crisis, and what would that crisis look like?
Well, I agree with everything you say, Gene.
You can stop there.
And
oh, good. He said "and," not "but."
Not but. And the problem is that the fundamental problem is that members of Congress or administrators do not make the connection between strong intellectual property rights and innovation.
Right.
So they all want innovation. I think most of them want innovation, and they will tell you that, you know, top to bottom, yes, is between more innovation in the United States and less, we would vote for more innovation. Where it breaks down is that they do not all agree. In fact, the majority disagree with the proposition that in order to get more innovation, you need a strong, robust, reliable, enforceable intellectual property system. And the reason for that lack of connection, there used to be. The founders saw it, it's in the Constitution, they connected the two, right? For the progress of the useful arts, they provided Article 1, Section 8, Clause 8. Okay, so they made the connection between the progress of the useful arts, and so the advancement of innovation, and the system of law that supports that. And it's been like that for 200 years. The problem is in the last 20, 30 years, whatever, that connection has been broken. And it's been broken for a variety of reasons, but you know, primarily you do have large multinational corporations that have grown to be so large that they, from a business perspective, do not need intellectual property protections for their own business. And in fact, the more intellectual property laws you have in place, the more robust the system is, the more expensive the cost of innovation is for them to acquire it. So they have been pushing, not because they're bad people, it's just that their business interest is to decrease the strength of the intellectual property system. So they've been breaking the connection between IP and innovation. This is the biggest problem. And I don't know, I mean, I don't know that you need a crisis to solve that. That's not the issue, because they'll agree, people agree that China is a problem, that we need to compete with China. But they do not agree necessarily that in order to do that, you need, at least as a necessary minimum, strong intellectual property rights. That's what needs to be reconnected here. And how do we make that connection? Well, a lot of the stuff you do, and these conferences, and the blog you maintain, and the stuff we do at C4IP, and all the literature we put out, and the advocacy, We put out a scorecard at C4IP where we give grades to every member of Congress, every senator, every House member. We give grades from A to F, and we say expressly that these are graded based on their votes on intellectual property laws, but they reflect their support for innovation. And if you have an A+ on IP, which is what we give you, then you're A+ for innovation. If you have an F on IP, no matter what you say, then you're going to have an F for innovation. And hopefully, slowly, one member by one member, we already saw improvements from last year. Slowly, some will pay attention and will make that connection again. But it's a hard road ahead. Because we've been on this downward path for the past 2-3 decades.
Okay. Vince or John, do you have any
Sure.
response? Go ahead, Vince.
Sure. So I'm going to take a little bit of a counterpoint to the congressional relief angle.
You say that almost derisively.
Yeah, so my thoughts are I'd love it if Congress would just come in and fix 101 and make it a lot easier and more definite to know what patent protection you have. However, my personal thoughts on this are that whenever we have another statute or regulation or Congress gets involved, it just kind of opens the door again to who knows what, right? So maybe there's a statute that comes out and then it redefines 101. Now the Federal Circuit has to go think about it again. So as we sit here today, we've got about a little over a decade, maybe almost 2 decades worth of case law explaining what 101 is. Like you said, the body, you said the dead body. But there are some outs to 101 that there didn't used to be, right? You could beat step 1 now. You could beat step 2 with questions of fact. When it first came out, it was the kind of thing where you were just dead if a district court said your patent was invalid. Now there are all sorts of ways that you can navigate that law, and there is more certainty because there is more case law and we have more strategies. If we go and add a new statute or change the law, who knows what that'll be? And I'll tell you that will, at least in the short term, stifle investment, stifle patent owners' ability to do anything because everyone will think, well, it's changed. Let's wait and see what the Federal Circuit has to say about it and whether this is going to actually be meaningful or not. So as a litigator who's trying to get definiteness for his clients in the short term, I can tell you that as things stand today, if we just don't rock the boat, I can guide my clients to a resolution. And I even though the answer is that some patents are not as good as others because of 101, we can still advise our clients accordingly and have some relative expectation of success. Mm-hmm.
So I disagree with you, but I understand, and it's just like a gentle disagreement, but because I get where you're coming from, right? How many of you just in the audience would love to go back to Bilski being the law? I mean, I would, right?
Too, yeah.
And the thing is we thought Bilski was the end of the world there for a while. It's not. It's going to kill a bunch of old patents, and Bilski now, in comparison to Alice, is like, my God, can't we just go back to that crappy law instead of this new crappy law? And so I get that. I do think PARA, though, is maybe not as clean as I would like it to be, but I think it would require special malfeasance to interpret that, if it passes the way it's right now, incorrectly by the Federal Circuit. Because I mean, it's clear to me what the intent is, and I think it would solve a lot of problems, but who knows? Andrei, it looks like you want to say something.
Well, so Vince makes a good point, which is every time you have a new law, there is going to be a period of uncertainty necessarily, no matter what, because that law has to be interpreted. So the courts will have to interpret it. Even if they interpret it correctly, you still have that period. So I get that. But the status quo, Vince, I think is untenable. By your own description, when you said that basically the state of Section 101 is the state of obscenity, which is a good summary, equating 101 patent law to obscenity. You can't, you said correctly, I believe, you can't advise your client whether you're going to win or lose until you see the motion for, after you file the lawsuit. I mean, that's crazy. I mean, that's not a normal system. How are you how are you supposed to transact? How are you supposed to transfer patent? How are you supposed to value patent rights if you need to have litigation filed and then an opponent making some arguments for you to know if you have a valid patent or not? That just cannot be good for a country like the United States in the long run. So something definitely has to be done. Now, I will say this, and this, I may be the only person in the world who thinks this. If somehow the courts would say, okay, we adopt the PTO guidelines from 2019, and we're going to stick to them, I think that would go a very long way to solve the problem. Without necessarily having new legislation. But they're not doing that, and they're not about to do that, and nobody, a statute could be passed that says the law on Section 101 shall be as in the guidelines. Take a look at the guidelines. But as I said, I'm slightly biased for those guidelines.
You sounds like you really like Trump's first director of the office.
Well, I was going to say it really depends who the director is. Jim's point, John's point from a minute ago, that it's not to the patent office to make these decisions, but the patent office really is in the best position to figure these things out because they see 750,000 applications a year, year in and year out. They have a lot of experience with the different technologies, and they really could, if they do it correctly, depending who the director is and so on. But really, just the staff is really capable of coalescing all the experience. But the problem is you have a divided government, and the courts don't have to listen to what the administration says.
So John, I really liked the guidelines from 2019.
I do too.
And I thought that. And I don't know whether this is what you were trying to do with them, but I think it set like a safe harbor. And one of the things that I've talked about, we've had conversations about a lot, is that what's infuriating about 101 to me is these, by and large, are innovations that could and should be patented. And if we knew what the rule was, we could describe them so that they are patented in a way that they'll stand the test of time. And that's what I thought was really the genius of the 2019, because it's like, integrate a practical application. Don't leave it hanging. Mm-hmm. If it's practical and it solves a problem, then that's the safe harbor. So go there, describe your inventions, let us know what they're actually going to be used for. Don't hide the ball. Yeah. And that seemed to also be consistent with 112 law and the whole purpose of the patent system. I don't know what, as you know, I'm not prosecuting anymore, I'm not drafting cases anymore. I don't know what you guys do today. I mean, because it's not easy to get something from the patent office, but you can. Mm-hmm. If you do a good job, you can, but then you can't have any real sense that this is going to hold up. I mean, so yeah. What is your strategy to try and deliver assets that matter, I guess?
Just brain dump. Throw as much against the wall as you can and see what sticks. Don't use throwaway dependent claims. Every dependent claim must have a purpose, a technical purpose, especially if you're in AI. There is no guarantee, and I don't know. I'm at a loss.
Well, but is that like strategy? If you're doing that with your dependent claims, then that means you have to have a more robust specification, and it kind of like is like wax on, wax off.
Yeah. Well, like you said yesterday, patents used to be 2 or 3 pages, and now they're 50 pages, right? And that's a reaction in large part to 101. I don't look. We know. We even not put the guidance aside. We know what the rule is, Gene. The rule is supposed to be any means any. Right? Any new and useful discovery or invention. And I agree with Vince. It's like what Reagan said, the scariest words in the English language are, we're from the government and we're here to help. And Congress has a really good chance to muck this up. And so I think ultimately what should happen is the Supreme Court comes to their senses. Right now we have a Supreme Court who's not afraid to overturn precedent, right? We've seen them overturn Chevron, Roe v. Wade. We see them do this. There's 5 supposed textualists on the court right now. I'm putting Roberts aside because I don't think in a lot of ways he has any principles. He's just concerned with not rocking the boat and preserving his legacy. But the other 5 conservative justices supposedly are textualists. And if they looked at it and said any means any, then maybe that would solve the problem. And at this point, so I thought para, coming into this new Congress, I was going, all right, this is it. This is our chance. Let's pass para. And I've talked to a lot of people in the audience today, and no one I've talked to has given it higher than a 0% chance of passing, which means we're back to, please, Supreme Court, take this up, fix the problem you created, just do something about it, right? We can't keep going like this.
I should say that the problem is created by the Supreme Court, but really, really amplified by the Federal Circuit. Look, if you look at Bilski, Alice-Mayo, Myriad, okay, what exactly are those cases specifically, those 4 cases? What are the facts of those 4 cases, okay?
They're all bad. They're all real bad cases.
Well, the facts,
Yeah.
right. So
You wouldn't have picked those cases to make any kind of law.
Well, but you would say, and I think a lot of people, not everybody will agree, but a lot of people, even on the pro-patent side, will say, those examples probably should not get a patent. Okay, so you have an electronic escrow, financial escrow accounts. Escrow transactions have been done for time immemorial, and now they're putting it on the internet or on the computer. So we can agree, more or less, the Supreme Court says that is not the useful arts. That's the financial arts or whatever. It's just nothing technical there. It's nothing industrial there. So that's their pronouncement, that escrow accounts are not within the patent system. Okay. A fundamental law of nature. Okay. You're observing a fundamental law of nature. Okay, we can agree. I mean, there's some people that say discoveries is in the Constitution and that means everything. But I think most people will agree that if you walk in the forest and you stumble upon a mushroom, that mushroom is not patentable, not within the patent system. You haven't improved it with any technology. So basically, if you just take the facts of those 4 cases, I think there can be broad agreement that limited to those facts, those cases are not wrongly decided. What's happened after that, though, is that the Federal Circuit has taken those 4 cases and put the theory on steroids. And you get to a place where you have, like in American Axle, where it is, it cannot be more technological and more mechanical than that. Maybe they didn't like it because it was insufficient disclosure, so kill it on 112. I don't know, they didn't do the analysis. But certainly under 101, an automobile axle and the features of that automobile axle have to be patent eligible. And the Supreme Court never said that it is not patent eligible. Or the charge point case, with a car charger. The Supreme Court never said that type of stuff is not within the patent system. There's so many examples like this. So I think, to have a more modest goal here is the Supreme Court doesn't need to overrule its 4 cases. It needs to overrule some of the Federal Circuit cases that came after that and constrain them and then tell them, what we warned you about is that if you're not careful, you're going to swallow all of patent law. It's in those cases. And you're swallowing all of patent law with these subsequent decisions. So I think, if the administration would advocate for a cabining of the Federal Circuit jurisprudence and get the Supreme Court, take a case, it has to be good facts, get the Supreme Court to say, you've gone far away from what our 4 cases have told you, bring it back to the core principles, pure business methods, financial transactions, for example, pure laws of nature without technological improvement. Beyond that, okay, those pure mathematical principles, okay, those are out. But beyond those 3 basic pure tools of technology and science and so on, beyond those 3 things, or whatever they want to say, just make it clear. That's it. You're swallowing all of patent law. So I think there is an opportunity through advocacy. If I also advocate for legislation, but that takes a long time, and but beyond that, I think there's an opportunity for the administration to advocate in the Supreme Court in the next couple of years to rein in the current state of the law.
So that's interesting. You basically you're advocating for, in a way, for a definition of what's abstract. It's everything except for these enumerated things. Right?
Yes, and we sort of did that in the 2019 guidelines, right? We said here are the abstract categories that we can discern from the case law. So what we told the examiners is you don't have to go backwards. You don't have to try to analogize to some pre-existing case. We've done that for you, and we've categorized the mass of cases into certain categories, okay? Pure mathematical formulas, right? 2 + 2 = 4, whatever. That comes from the Benson case, probably correctly decided, right, with the transformation from decimal point to binary and vice versa. And okay, so that's one of them, okay? Pure human interactions. People like to give this ridiculous example of, dance moves or marriage proposal, or okay, marriage proposals, pure human interaction. We've said those things are not within the patent system. They're not the useful arts and the pure laws of nature. Yeah, so have the Supreme Court say, these are the categories that we have in mind. We've looked at all the cases. These are the only things. To be honest, it's not their role to do that, right? This is for the legislature to do. It's massive policy for the United States. But they're not doing it. They haven't done it for 200 years, the legislation. So the Supreme Court's doing it. Okay, so if they're going to do it, make it clear what it is, and everything else goes.
Mm-hmm. So if I can give a bit of a counterpoint to that, and again, these aren't my views necessarily, but when's the last time the Supreme Court did something that strengthened patents, right? So that's my fear.
Diamond versus Deere and Diamond versus Chakrabarty.
That's correct.
And they only did that because they were trying to justify their existence to Congress because the Federal Circuit was gaining steam. And they,
So I don't necessarily, but I think it would be great if the Supreme Court could go and give some more definiteness and rein in 101. I don't know if I have the belief that that'll ever happen. But to give it a little bit of a silver lining, I know everyone thinks that there's some cases out there that are saying that all these hard physical mechanical things could be 101. But I'll give an example. There was a case, this is maybe 4 or 5 years ago now. I think it was Bosch was maybe the defendant. It was an appeal of an ITC case, and Bosch tried to argue that a table saw was 101. And the good thing is, if you want to hear something very funny to a patent lawyer, you listen to that oral argument, and you'll hear the judges in the Federal Circuit getting very upset, going, "But it's a table saw. It's a table saw. How is that abstract?" So that was comforting to hear, that at least there is some reason going on behind the scenes, and that it's not going to go that far in one direction. But absent that, unless you have something that's a table saw, and I know the lawyer who made the argument who was like, "Oh, anything could be abstract. I'm going to make this table saw abstract." I saw someone try to say a shoe was abstract, shoelaces. It has devolved, but there are some safeguards. And the shoelace case, the motion was denied. The table saw case, the Federal Circuit said that is not an abstract concept. So, there are guardrails, very, very small and flimsy guardrails, but they're there.
Mm-hmm. Gene, I still think we should go with your test of eligibility.
Yeah, if you throw it at the judge and it leaves a mark when it hits their head, then it's not abstract. And if I throw it at the judge and I'm not going to get sanctioned for having done so, then it's imaginary and it must be abstract. And I say that tongue in cheek. I asked people, there's now, and I don't think this is the case, but examiners, and they got past this, but cameras are being rejected as being abstract in certain cases at the patent office. And I'm like, this is just ridiculous,
And And the reason they do do that, Jeannie, is because in those examples, the claims are written at a very high abstract level without enough specificity. They're result-oriented, for example, even if it is a mechanical device or a process for using a mechanical device. They're written at such a high level. And I'd like to hear from John on this point about how to write claims to avoid that. But that's really a 112 issue. This is the problem. Even if that's true, they shouldn't reject on 101. 112 is precisely for that purpose. They should reject under 112.
Yeah. So I want to pivot a little bit because I want to talk about, Vince, something we talked about in the pre-call about the venue and the venue-dependent nature of 101 and some of your strategies for dealing with that. And, I've thought about what you said, and just my preview to what's to come here is that the fact that it is so venue-dependent just strikes me as all the evidence you need that the Federal Circuit has failed. The Federal Circuit is supposed to have brought uniformity to patent law, and they have not. And the story Vince, I think, is going to tell us now is going to be my Exhibit A in that argument.
Sure. So, it does go without saying that when you're litigating patents, specifically 101, the more favorable jurisdictions to be in are in Texas generally, West Texas, East Texas. Although I will note that there was a very bad for patent owners decision that came out of West Texas, I think, last year, and then the appeal, Federal Circuit upheld Judge Albright's invalidation of some claims September of last year. So, West Texas is, they can grant 101 motions. In general, they'll do it at summary judgment. But when you look at, say, California versus East Texas, and you see that most of the cases invalidating claims under 101 come out of California, and very few of them come out of East Texas. When you're looking at venue, it's not a hard decision to make to say that East Texas is the better place to be as a patent plaintiff. That being said, we've been in some cases where, we have patents that our clients had taken to us. Others had told them there's no possible way. These are invalid. They're 101. They're never gonna see the light of day. And for that very patent portfolio, I know we beat a motion to dismiss, and they were found to have had a question of fact under Step 2, and then we got to pretrial conference summary judgment, and then Judge Payne actually reversed his initial motion to dismiss finding and said, you know what, they're not actually Step 1. They're not even Step 1. And the reason there was something I alluded to earlier, which is that came down to how you frame the abstract concept. So in that case, and this goes also to some patent drafting issues, in that case, the patent was about filling out forms on the internet, right? Filling out your auto-populating your checkout. So if you hear that as a patent lawyer, you say, okay, I see what you're saying. That's probably 101, right? Your initial reaction is, doing something over the internet with the web interface, that's got to be 101, right? Well, the claims actually were directed to that plus using this centralized database to do something. And the defendant in that case lost sight of the centralized database and just said the abstract concept is filling out forms on the internet. And that's where we were able to, drive a wedge between it and say, okay, well, you missed the abstract concept. It's not 101. And part of the reasoning was Judge Payne found that the centralized database was in the title of the patent, in the abstract of the patent, repeated numerous times throughout the specification. So I know you had asked me again at the pre-call, how important is it to have things in the abstract or even in the title? And very important, very important. So, I know, Gene, you're talking a lot of gloom and doom, but there are silver linings. There are ways to win. It is very fact specific, but you can win. You can beat 101. Like you said, it is very venue dependent, but you can.
So, what are those ways and strategies that you have to the extent that you can share them.
Sure. So I don't want to go try to not say too much on a recorded call that all my opponents are going to watch.
Right.
And then take those away. But I'll say the first thing is, number one, I don't want to say length of the claim, because if you go and look at that case I was just referring to where Judge Albright was affirmed on 101, the claim was a book. It was like 3 pages long. But generally speaking, the more you have in your claims, the better. The shorter and more concise a method claim is, the more likely it is that the steps you're describing are going to be abstract. And it's going to be harder to fit a lengthier claim into an abstract concept. You're going to have an abstract concept that has multiple clauses to it, filling out forms of the internet with a database and a something and another thing and another thing. And by the time you get to that abstract concept, it doesn't sound so abstract anymore. Also, the longer your claim is and the more stuff you have going on in your claims, the more likely you are to run into ordering of steps being important, because that's a factor that's important for getting around a 101 motion. And, the last piece is really just, again, very fact specific, but trying to find a claim term or two to latch onto as the inventive concept, to get a very good expert behind you to distinguish the prior art over that and say this is really the novel thing in the invention, and create those questions of fact. As a litigator, primarily on the plaintiff side, that is our focus. Find questions of fact, get past summary judgment, get to a trial, get a jury to understand it. Because, I like what they live by in East Texas, which is that juries in America are very good at deciding who the good actor is and who the bad actor is, and what the right outcome should be. And if you put that in their hands as to, is this an inventive concept, they'll get to the gist of it is this a valid patent? And when they're deciding it's a valid patent, they're going to look at obviousness, anticipation, 101 all together, and come out to that conclusion that you have, if it's not 102, it's not 103, they're probably going to find an inventive concept in there that's going to get you around 101 as well.
With a lot of these cases where they've gone against the patent owner, if you actually look at the patent, you look at the claims, you look at the ways things are described, probably 99% of us in this room would say, that's not enough. I wish they had done this. And if I had given you 2 patents and told you, okay, one of them passed muster and one of them didn't pass muster, again, 99.9% of you would be able to pick the one that did and identify the one that didn't. Where the problem becomes is you won't be able to articulate why. And then you have the next case where it gets twisted and convoluted, and then we're seeing, the PTAB saying an MRI machine is abstract, and it's just not. And then you see the drive shaft case, and it's like, no, this is not a natural law. It's just it's a thing that if you trip over, you're going to break your leg. So that's I think the problem. And so I think, and maybe we could talk about this in the last few minutes we have. I don't think the test that we have right now is any better than the Freeman-Walter-Abelli test. And that test got thrown out finally because the Federal Circuit did finally admit that this does not direct any decision. If you go into the decision-making analysis fundamentally believing more should be patent eligible, you come out with the claims eligible. If you go in with a view from like a Judge Dyke kind of view of the world that less should be patent eligible, you conclude less should be patent eligible. All the judges use the same test, use all the same language, and every one of them comes to a different conclusion. Well, that's no test at all. And that's, I think, where we're at. Vince, did you want to say something?
Sure. Really what it comes down to, I think, at a base level for a judge deciding this, I think, is just the come on test. Like, oh, come on, that's not new. Look at that. There's nothing there, right? Which you can see by just looking at it. Now, when you're prosecuting patents, specifically in AI or you're doing machine learning, and look, prosecutors, I'm not a prosecutor. Of course I could, but that's not what I do by trade. Now, everybody wants broad claims, right? That's what you're taught, right? Go broad until you hit resistance. Then as soon as you get that resistance and you get the broadest claim possible, that's what's good for your client. As a litigator, I can tell you that those broad claims, they get you into trouble, because now all of a sudden you have this really broad claim that kind of looks like it's been out there in the art, and that even though you're not doing a 103 analysis at 101, it's something a judge can look at and go, come on, that's obvious.
Yep.
Come on, that's been in the art. And once you get there, then you're dead on 101. So with things like the training of an artificial neural network, or something in machine learning, or even AI patents, you really want to make sure your claim has some meat in it to latch onto. That's not just storing and manipulating data. If you're gonna manipulate the data, you better claim how you're manipulating it in a way that no one else has done before.
So
Right.
I don't want to disagree with what you said, because I think you just described things accurately. And we all were just probably shaking our head when you said, well, there's nothing new there, so therefore it doesn't pass muster under 101. I mean, and we have come to, so 2 + 2 = 5, right? I mean, that's like from 1984. It's like, no. Newness is 102. We have a Supreme Court case that says that told us not to do what you just said to do.
I didn't say to do it.
And we all agreed. Why did we all agree? Because Vince just accurately described what the law is of the Federal Circuit. 2 + 2 = 5. And it's ridiculous. We have a newness section. So what we're doing is, under 101, deciding whether this is new enough or not new enough without applying any prior art.
Not even taking judicial notice.
Not even taking judicial notice.
Yeah.
Nothing.
And it's easy because it's a question of law.
And I feel I'm asleep. I am sure I'm asleep, that this is a dream, because this can't possibly be reality. I will wake up and none of you will be in my bedroom, right?
I certainly hope so, Gene. But this is a consequence, by the way, of the 1952 Patent Act. Judge Rich predicted exactly this. The whole point of the 1952 Patent Act was to separate the types of invalidity, separate newness versus obviousness versus 112 type of things, specificity, and 101 is separate yet again. So the 1952 Act precisely worked to separate these lanes. And in a Section 101 decision in the late 70s, Judge Rich wrote, "You're confusing the lanes again. We worked really hard to separate them. You're confusing them." And we went, and it was fixed for 20 years after that. But now we've coalesced the lanes again, and this is exactly what's happening.
Yeah, because that was Judge Breyer wanted to cross lanes, or cross the streams, a Ghostbuster reference. Don't cross the streams. And Judge Breyer specifically, throughout his entire career, disagreed with that, and finally in the Mayo case got his way. Newness is now under 101, and it's under 102. So you, patent attorney, have two newness hurdles, one with prior art and one without prior art.
One's a question of law.
And one's a question of law, which we don't care what the jury thinks, or how cool it is, or fascinating it is, or how revolutionary it is, as Judge Lynn said in the Ariosa case, that this is, and nobody disputed this is one of the top 10 medical innovations of all time, given the amount of harm that was mitigated to zero. But no patent for you, because that's just not the type of thing we want to protect in America, is useful medical innovation. Why would we do that? All right, so on that happy note, why don't we go into final thoughts? Andrei, I'll give you the first whack at your final thought. Is there a takeaway message that you want to leave the audience with today?
Yeah, look, I think we can be hopeful in this area. I do think, as I said at the beginning, and the panelists here described in more detail, there's a lot of decisions now. The body of law, dead or alive, has grown, and that's helpful. If nothing else, it's helpful to delineate the lines. So it is easier now than it was, let's say, 5 years ago, to predict how the case might come out under Section 1. And we do sort of know, as you've heard already, what some of the key features might be when you prosecute patents to include to survive a Section 101 motion, and what to put in your complaint when you file a complaint to overcome a motion to dismiss on Section 101. So there is more right now from the cases. The guidance from the PTO and the decisions in the last 6 years are also helpful. That's a whole different body of law that I think is consistent in result, but approaching it in a more systematic way. Millions of patent applications issued in the last 6 years with this law. So I think that's helpful as well. And we do have a legislative process. Whether PIRA will pass or not, the issue is being discussed in Congress. No question about it. And we do have a bill that is a good bill. Can it be improved? Sure. But it's a very good bill that we have pending in both houses of Congress right now that can be discussed. And I urge you all to voice opinions on this, write op-eds, put something on Gene's blog to explain why you like the bill. If you don't like the bill, don't say anything. Just kidding. But we have action in all three branches of government, and that is it's a good thing. And I do think eventually we will come to a better position.
Awesome, great, thanks. John, your final thoughts?
I hope you're right, first of all. But second of all, to stress what I've already been talking about, but more from a higher level, when you draft a patent application, from the top to the bottom, think about the technical effect and write the technical effect in. And I'm not saying to misrepresent the invention if there really is a lot more to it than just the technical effect, but there is a way to write things, if you have that in mind, that can give your litigators a hook down the line. And so I think it's really important to do that, however you do it. And if you don't want it to work its way into the claims at first, that's fine. Make sure there's a lot of technical effect in the specification, but you really have to do it. When it comes to prosecution, push back on all 101 rejections as strongly as you can from the start, not only to save your client money through the rest of the ensuing rounds of prosecution, but really to help your litigators out. Again, I think 101 personally is an area where it's kind of hard to create like a negative prosecution history for your client. I mean, what are you arguing? That your claim is patentable? And so I think you really just have to always be hitting that home to make the record clear.
Awesome, great, thanks, John. And Vince, the final word goes to you.
Sure. So, I know beginning of it was a lot of doom and gloom. I said I see a silver lining.
That's why I had you go last, because I think, surprisingly, I think you're going to leave us with a good message, some hope.
Sure. So I would love nothing more than for there to be some legislation that comes in, and I'm 100% behind the new legislation that's out there. I just want to make that clear. I think it's great. I don't think that if it passes the Federal Circuit is going to go and then morph it into something worse for us. I don't think there's any way. But living in the world we are in today, not being able to wake up in your bedroom, right? We're here. Yeah. I know I'm here. I want to be able to give my clients the advice they need to get through the situations they're currently in, because nothing's going to change for them in the short term or the near term or even the next couple of years. I will say that from the perspective of people investing in patent cases or investing in patents or buying patent portfolios, the risk of 101, folks looking at 101 have downplayed that risk more now than they were, say, 10 years ago. I will say 10 years ago, in the litigation funding industry, funders would not want to invest in a case until you got past the motion to dismiss for 101. That was just 100%. They would not put any money into a case until you got past 101. Now, it is an afterthought. There's a memo and people, put together expert declarations before you file a case to make sure you have a basis, but it is nowhere near the risk it was 10 years ago or the fear that it was 10 years ago. Now, the law might not have changed that much, but silver lining is, I think, more people are winning, more plaintiffs are winning. You're getting to a trial, you're getting questions of fact. Juries are deciding the issues more now than courts than they were 10 years ago. And, the value of patents has ticked up ever so slightly over the past 5 years, I think, when it comes to 101.
Great, awesome. That's a good place to leave. We have some hope. Things are at least better than they were. And if we all stay engaged, I think we will in time find a much better place. But it is going to take involvement, I think, in education. So if you get the opportunity to talk to a senator or a member of Congress, you're a member of Congress, you're a senator, take that opportunity. Talk to their staffers and participate. So thank you, guys. That was a great conversation.
Thank you.
Thank you.